Specifically, the concerns, I think, what you're asking is the way that it was portrayed to the public as to who made what decisions and who agreed with what decisions, quite frankly.
That's attorney Kevin Glogauer out in Kentucky. He represents anonymous grand jurors from the Breonna Taylor investigation. And he won a motion for the grand jurors to be permitted to speak publicly. Now, they've still have retained their anonymity, so we don't know who they are, but they have released some statements now. So we're getting word and the perspective of actual grand jurors from the Breonna Taylor case. Again, another unprecedented time here in this entire case. Let me put it up on the screen for you. And this is what anonymous juror number 1 is saying. The grand jury was not presented any charges other than the 3 wanton endangerment charges against Detective Hankinson. The grand jury did not have homicide offenses explained to them. The grand jury never heard anything about those laws. Self-defense or justification was never explained either. Questions were asked about additional charges, and the grand jury was told there would be none because prosecutors didn't believe they could make them stick. So that's the perspective of one of the grand jurors speaking on behalf of himself. This is uncharted waters for me as well, folks. Let me bring in Court TV special contributor Ashley Banfield. Ashley, so now we're hearing from a grand juror who says, listen, we never even had the opportunity to consider homicide charges because he never gave them to us, never told it to us, never explained it to us. We didn't have that option.
No, they didn't. And I think this will be sort of a real learning moment for everyone. If you haven't sat on a grand jury before, you don't always get that. Generally speaking, what the state does is present to you a case it believes it can win. Because otherwise, there could be ham sandwiches indicted everywhere, right? And so oftentimes that is exactly what happens. That's not to suggest that there haven't been, say, grand jury experiences that have been nefarious, that prosecutors who are friendly, say, with a potential defendant, skirt the facts a little and maybe don't present everything. We looked at a case with Ahmaud Arbery where there were no charges, and it wasn't even a case of, presenting anything to a grand jury. They just arbitrarily decided, these guys are good. And then when we saw a lot more evidence, we realized this absolutely should have gone before a grand jury. This, without question, should be something that a regular jury should see. But, this is a very, very tricky area to navigate. It should not be considered for a moment, Vinny, I think you'll agree with me, that just because Daniel Cameron did not present homicide charges to this grand jury, that he was trying to keep homicide charges from the grand jury. I don't want anyone to go away from this thinking that that's exactly what happened. I don't know what happened, but I am saying that it is a standard operating procedure for a prosecutor to present charges to a grand jury that it believes it can win and not present an entire plate of spaghetti to toss at a refrigerator.
And ethically, that's what they're supposed to do. I mean, they should only present charges that they believe they can prove beyond a reasonable doubt and at a minimum have probable cause for. So they're one of the gatekeepers. So I think that the Attorney General here doesn't necessarily have a legal problem. He didn't do anything illegal. I think it's a political problem. And the reason I'm saying that is I want you right now to listen to a couple of statements from the Attorney General. It was a Q&A after his press conference where he addresses some of the issues addressed by the grand juror. Let's take a listen.
Did the grand jury ever consider manslaughter or reckless homicide or those kinds of charges? And if not, please explain why. And do you anticipate any other charges, or is this it?
I won't get into the specifics again of the proceedings themselves are secret, but what I will say is that our team walked them through every homicide offense and also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
Were they presented with any charges for Mattingly or Cosgrove?
Well, what I will say is that they were walked through all the homicide offenses, and with that information and the information and facts that were provided to them that we uncovered in our investigation, they made the determination that Detective Hankinson was the one that needed to be indicted here.
All right, as I listen to that, either the Attorney General's not being truthful or the grand juror's not being truthful. Recordings of the grand jury were released, but it was just the testimony. It wasn't the arguments or the presentation or the deliberations of the grand jurors. So to me, if he lied, that's a political problem. What he did and what he presented and how they did their work in front of the grand jury, not illegal.
Well, I look at that as there was total legal speak going on there. And I think Daniel Cameron probably didn't do himself any favors at all, because what he was effectively saying to lay people was, it's on the grand jury. They chose that. That was their decision. They were walked through everything. But you can't use those kinds of terms, because presenting or walking through, it's different. There's technical terms. Giving them a charge form with homicide is different than telling them that this is what happened. But here's what what I'm going to ask you to decide on: yes or no. The other charges regarding the third officer, but not regarding the first two. So I think it's unfair. I'm probably not making as much sense as I'd like to be making right now, but what I think I'm trying to say is that I really think that he punted politically to make this a grand jury decision. And whether the decision's right or wrong, I do believe that the attorney representing the grand juror said that the chief complaint that the grand juror has is that you're making it out to be this is all on us. It's not all on us. We had one choice to make, yes or no, to the third officer, but you didn't give us the choice. And I think there's if you re-listen to that comment, you'll hear how he is accurate, but his meaning to lay people is different than what it should be. And I'm just going to suggest here that there's a quote here that the attorney for the grand juror said, the major complaint was the way in which the results were portrayed to the public as to who made what decisions and who agreed with what decisions. Because if you listen to Daniel Cameron, he says, well, we walked them through everything and they made this choice. And this grand juror is saying, no, we actually didn't get all these choices. And here's another quote. The grand jury agreed that the officers who shot Taylor were justified in returning fire. This is something that Daniel Cameron said. The grand jury agreed that the officers who shot Taylor were justified in returning fire after they were shot by her boyfriend, Kenneth Walker. But the juror says, not necessarily. We didn't agree. And this is a quote. We didn't agree that certain actions were justified. And we did not have the homicide charges explained to us. So I think you've got to be really careful when you look at the technicality of a grand jury. And I think Daniel Cameron should have been more careful when he explained the process. But I think we're all living in a very political world, aren't we? And I think anybody who gets, who has to get in front of a mic and speak on this issue is going to be damned if he doesn't, damned if he doesn't.
Yeah, but if you are the Attorney General, you're investigating it, and you don't think there's evidence, get up on the microphone and say, listen, we investigated this for 2 months. There's not enough evidence. I am not going to present homicide charges that I cannot prove in court. That's all he had to do, but he didn't.
That's
and that's
all
a
he
problem.
had to do.
You're right.
That's a problem. That's the whole problem. That's what brought out this process and this extraordinary moment where we're seeing a grand jury say, hang on, don't you dare punt this on us as though we're a bunch of racists who don't care. That wasn't the issue. I'm not so sure that these grand jurors are taking so much issue with the decision. They're taking issue with Daniel Cameron saying, I didn't do this.
Right.
This was all the grand jury's doing. Yeah.
I got to play one more thing for you. This is from ABC News today. Sergeant Jonathan Mattingly, one of the officers there, gave an interview, and I want you to listen. And again, this is from ABC News. He was involved in the raid that led to the shooting death. Spoke to ABC News today. Let's take a listen.
We would have either served the no-knock warrant or we would have done the normal thing we do, which is 5 to 10 seconds, to not give people time to formulate a plan, not give people time to get their senses so they have an idea of what they're doing. Because if that had happened, I'm telling you, Mike, if that had happened, Breonna Taylor would be alive.
This is, and I never thought of it this way. What he's saying is, if we had executed it as a no-knock or just gone in 5 seconds, you know, Walker wouldn't have had time to get the gun, there wouldn't have been firing at us, and nobody would be dead.
You know, I think he makes a good point. I think everybody instantly listening to the story of Breonna Taylor thinks, what do you mean police officers can just bust open my door and arrest me in my own home? This is typically how you get bad guys. Because if you ask pretty please, you know, drug dealers are smarter than that, and they'll be out the back door in a heartbeat. So there's a reason for no-knock warrants. It's not that it's just police behaving badly. I mean, think it through, folks, right? I think in that instance, there's a lot of argument about whether there was a knock, whether there was a request to you know, identify yourself. One witness who lives nearby said that he or she did hear the officers identify themselves and request to enter and knock. Others say that didn't happen. But again, this has become a very political story, right? So it's a little tricky given the fact that people are weighing in. I remember during the Michael Brown case, there was a lot of politics that played into what witnesses said to police. And then later, like a lot later, when the Justice Department did a review and a full investigation, they recanted and said, I just wanted to be part of the story. I just wanted to belong. I heard it on TV and I said I saw it instead. So I get it. That can happen. But listen, I mean, look, if this were me, I would be beside myself, just beside myself that this could happen. But we have to always take into account all sides in these cases, and you can't just go with a narrative because it's more convenient. Absolutely.
All right, Ashley, I'll see you again at the top of the hour. We have big news tonight in the Parkland school shooting case, and we'll talk about that in the